May it please the Court, Mr. Skinner, Mr. Miller. The Court of Appeals endorsed Pleasant Hill's attempt to circumvent an express statutory limitation on the duration of economic development urban renewal areas. And this Court should reverse that decision for two reasons. First, because the Court of Appeals did not engage in any kind of statutory analysis to determine whether or not the legislature truly intended to create a class of perpetual economic development urban renewal areas. And second, because reading the Pleasant Hill urban renewal documents in conjunction with Iowa Code Chapter 403 leads to the conclusion that Pleasant Hill cannot perpetually extend the Copper Creek economic development urban renewal area. With that, we turn to the first point. The Court of Appeals decision engaged in the following syllogism. In 1994, the legislature passed an amendment to Iowa Code Chapter 403 limiting the duration of economic development urban renewal areas to 20 years. However, it made that amendment prospective only. The second premise then is that Pleasant Hill created its Copper Creek urban renewal area prior to the effective date of the 20-year limit. Therefore, according to the Court of Appeals, the Copper Creek urban renewal area can continue in perpetuity. Now, there are two assumptions embedded within that syllogism that the Court of Appeals did not engage in any kind of analysis of. The first assumption is that Iowa Code 403.5 allows Pleasant Hill functionally to exclude itself from the operation of the 20-year limit because 403.5 allows a municipality to amend or modify its existing urban renewal plan. Your Honors, the exhibit and demonstrative we've provided the Court demonstrates in stark relief the, quote, modification or amendment that Pleasant Hill has attempted to engage in this case. The larger of the red circles in Exhibit I-3, which is included in the appendix at pages 611 to 613, shows the original Copper Creek urban renewal area. The smaller red circle shows the 2013 amendment that the City of Pleasant Hill has attempted to attach to the original Copper Creek urban renewal area for the express purpose of utilizing the TIF revenue generated by the older, larger Copper Creek urban renewal area.
Can I just ask a factual question to clarify my mind? The only property, am I correct that the only property that is going to get basically the property tax deal, the TIF financing, is for more than 20 years is the property that was within the 1994 boundaries? Is that right?
No, Justice Mansfield, I don't think that's Pleasant Hill's intention in this case. I think the intention is, and in fact this was expressed by Pleasant Hill's bond counsel at trial, that the purpose of the TIF in the Copper Creek area is to generate an increment that can be utilized in other areas. In fact, Pleasant Hill's bond counsel was quite explicit that the TIF revenue generated within the original Copper Creek urban renewal area doesn't need to be spent in the original urban renewal.
I understand that point. It doesn't need to be spent within the original area because, in their view, because they've combined the areas. But the area that wasn't designated in 1994 that was added later, that has a 20-year sunset, and after that it's subject to regular property taxes. Is that right?
I don't know that that would be the Pleasant Hill's position in this case. I think the position of Pleasant Hill, as I understand it, is that any amendment to the original 1994 plan is somehow graced or blessed with this perpetual status because it is attached, it is functionally an amendment to a pre-20-year limit plan. And so it can continue to be amended as many times as Pleasant Hill sees necessary in order to affect the purposes that they have in mind. Which is exactly the opposite of what the legislature intended by writing into the code an express 20-year limitation.
Now, why is that? I mean, the whole battle, I think, is over what the legislature has done with that deadline. This TIF was created prior, that's not disputed, prior to the 1994 legislation. And so I think to anticipate the argument of your opposition, it's whatever was created prior to 1994 isn't subject to the 20-year limitation, is off. The investment expectations were made prior to 1994. It just doesn't get drawn into the scope of the statute at all, and that was the legislature's intent. So tell me why that's absurd, or tell me why that can't be, or give me the construction that defeats that.
The absurdity here is the interplay between the applicability date language and the provision of the code, 403.5, that allows for modification. The applicability date language speaks to plans existing. The modification provision in 403.5 speaks to an existing plan being modified. But we're not really looking at a modification in this case. It's a wholesale substitution of a new plan in an attempt to circumvent the 20-year limit. And if we read all of the documents together, if we read the TIF ordinance, the 94 plan, 403.5, and the applicability date language together, we can chart a harmonious course for all of these documents. What we can see is that Pleasant Hill intended that the original plan would expire after 20 years. It intended that in the text of the original TIF ordinance that the original TIF money would only be spent in the original Copper Creek urban renewal area.
Why does their early intent matter in terms of trying to figure out what the legislature meant with this somewhat ambiguous deadline?
Because the legislature, in making the statute prospective only, could have intended to avoid any constitutional challenges that it may have seen if it had impaired existing bond obligations. The legislature could have rightly looked at the situation and decided cities like Pleasant Hill have natural sunsets written into their plan documents. These plans will expire under their own terms, and any new development will occur under the auspices of the new duration limit. However, Pleasant Hill is attempting to circumvent that intent by essentially removing any kind of limitation provision contained in its plan documents.
Well, was the prior statute then just unlimited? You could go ahead and have one of these areas developed, and it was unlimited at that time? And
That's
then
correct.
The statute put the limitations on them?
That's correct. The original economic development areas could exist in perpetuity, and that is still the case for developments based upon slum or blight, but not for economic development. And so the legislature clearly had in mind a desire to limit economic development, which is why Pleasant Hill's position in this case is absurd, because it renders a class of TIF districts perpetual. And it is for these reasons that the Southeast Polk Community School District would request that the court reverse the Court of Appeals decision. The remainder of my time will be given to the concerned citizens.
Thank you, Mr. Lande. Mr. Dickey.
Mr. Chief Justice, and may it please the court, Gary Dickey appearing on behalf of concerned citizens of Southeast Polk. Justice Appel, I want to try to address your question. When the legislature created the 20-year sunset in 1994, they created separate tracks for economic development areas, right? And one track is for those pre-95, in anticipating the change in law. Pleasant Hill and many other municipalities took advantage of that. The other track is for plans that are post-1995. So the actual language itself is not decided based upon the area. It's decided based upon the plan, and that's what's problematic for the city in this case. They had a 1994 plan for Copper Creek only, and they were proper to consolidate, but once they did that and adopted a new plan, or actually the language is approve a new plan, a post-1995 plan, they brought themselves, the Copper Creek development, or urban renewal area, within the 20-year sunset. Now, as an interesting quirk in the law, the sunset doesn't begin from the time the plan is amended, which in this case would have been 2006, going to 2026. It actually is a retroactive sunset back to 1994. So that's what the legislature wrote in the law, and a straightforward application of the plain language of that to the facts of this case requires the conclusion that their resolution extending it 20 years is improper.
If they didn't add new property to this original plan, could they have extended it in perpetuity?
Well, so it already existed. The property boundary is irrelevant to the discussion here. What is relevant?
If they extended the original plan without amending it and adding different pieces in there, and that's what I mean by property. If they stuck with the original plan, could that have operated in perpetuity by keep on renewing it?
Yes. Yes. So they could have shifted the geographical boundaries. I mean, they would have had some problems aligning their TIF ordinance with that, but they could have shifted the geographical boundaries of the TIF district, the urban renewal area, and not brought themselves within the 20-year sunset. But when they change the plan, when they approve a different plan, and they've done that several times. In fact, if you look at the title of their 2013 resolution, it's approving an amendment to their plan. That's what brings them within the 20-year sunset.
I'm looking at 403-1710, and it says economic development area means an area of a municipality designated by the local government. And then it says the area, division of revenue provided and stated in the plan shall be limited to 20 years. Why, isn't it the area that is covered rather than, and as long as they're not expanding the area that doesn't, that is subject to the unlimited TIF, and perpetual TIF financing or potentially perpetual TIF financing, what's the problem?
Well, I guess you have to read that in unison with the Enabling Act, right? So the Enabling Act says that does not apply to pre-1994 plans. So it's the timing of the plan is what is outcome determining in the analysis. And since their plan, they had a pre-1995 plan, and they were fine, and there wouldn't have been an issue even if they changed the boundaries. But when they come back in 2006 and consolidate, then that's what brings them within the 20-year limitation. And to get to your question, Justice Zager, is there has to be a purpose for this 20-year limitation. And so at some point, for this court to rule in favor of the city, this court's going to have to explain how the purpose of that is that 20-year limitation is furthered with their interpretation. And there's just none apparent from the record. I mean, intuitively.
Through the part of the language in here, and it talks about the original plan that the city adopted, and it says the plan shall remain in effect for 20 years, but it can be altered and for an additional period after the dates during which obligations are there. The urban renewal plan also states that the plan can be amended to include all these different boundaries, different projects, modify the objectives. Doesn't that seem to give them quite a bit of authority and power to go ahead and do exactly what you're saying they couldn't do or shouldn't do, which is amend the plan and also amend the boundaries?
To be clear, we're not suggesting that they acted improperly. They have the authority under Fultz and under Chapter 403 and their own enabling resolutions to modify, consolidate, change boundaries. There is, however, a legislative temporal restriction on their ability to use TIF. And once they did their urban renewal plan, which is, there's no real factual dispute that they've done several times, that brings them within the 20-year sunset. And again, it's a 20-year sunset from 1994 when they first notified the county auditor of their intent to divert funds for TIF. So we're not saying they've acted beyond their authority in anything prior to 2013. The specific act that was beyond their authority was the resolution in 2013 extending the area, the Copper Creek area, for another 20 years.
So you're saying the price of a substantive modification of the plan post-1994 is that the 20-year limitation kicks in? That's
how the legislature, that's how the statute and the Enabling Act, when read together, reads. And that, I guess that's the only reason that's the only reading that could carry out the legislative purpose, was to put a limitation on the economic development use of TIF, right? The thought would be there's a natural 20-year life cycle that these types of urban renewal projects ought to have, and after 20 years they run. But for those that have existed and have made investment decisions prior to 1995, we'll allow those to run a longer life cycle. But when you change that up subsequently, then that sunset applies. The court need not, I mean, in addition to this issue, the court could reject the resolution for another reason, and that's because the comprehensive developmental plan was not consistent with the resolution and the urban renewal projects. As a factual finding, the court essentially agreed that the warehouse project and these urban renewal projects were part and parcel of another, and that it wouldn't be consistent with the comprehensive development plan. The court simply felt bound under McMurray to not look beyond the four corners of the urban renewal resolution itself, which this court did in Knutson. So the McMurray decision and the Knutson decision are in tension with each other in terms of what extrinsic evidence can be considered. We would ask this court to adopt a Knutson approach, allow the district court to look beyond the four corners, and if that's the case, then the court has indicated we would prevail at the district court level.
Thank you, Mr. Dickey. Mr. Miller.
Mayor, may it please the court. Your Honors, Bill Biller here on behalf of the City Council of Pleasant Hill and the City of Pleasant Hill. I'm here with my co-counsel Brad Skinner, City Attorney for the city. I'll refer to my clients both as the city throughout my argument today. As this court has recognized repeatedly in the past, the Iowa legislature has given cities broad authority when it comes to determining economic development matters. This arises out of Iowa Code Chapter 403, and in particular, for instance, Section 6 of 403, which says cities have all the powers necessary or convenient to carry out and effectuate the purpose and provisions of the urban renewal law. In McMurray, this court recognized the purpose of extending cities' urban renewal powers was to address economic development, to stem economic decline and promote economic growth. And part of that economic growth to be encouraged is to bring entities into the state and into cities. The actions by the city in this case have all involved the lawful exercise of the city's broad authority and have been in pursuant to the development objectives.
I'd like to begin the inquiry the same way I did with your opposing counsel, and that is the legislature, it seems to me in 1994, clearly wanted to limit the life of TIFs for economic development purposes to a 20-year period. I mean, that's kind of a substantive legislative judgment. But they did put in, and I strongly suspect there's some constitutional motivation. They did put in the date limitation that we've been talking about. Why shouldn't we interpret that statute to say, all right, look, if your TIF plan was in existence prior to the effective date, you're okay. And you don't have the 20-year limitation. But don't fool around with the plan. You start changing the plan and start changing the geographic areas, making substantive changes, that puts you in a new ballpark. I mean, that's what I hear, particularly Mr. Dickey saying. That's his interpretation of the statute, and that might be rational. I would invite you to challenge it.
Yeah, thank you, Your Honor, gladly. It's clear from the statute that the legislature had a plan, as you indicate. And part of the school district's problem with their argument is that they read out the end note and the time limitation. There was a clear indication of how we're going to treat items before January 1st, 1995, and how we're going to treat them after 1995. And the school district simply says, well, no, it's all 20-year limitations. That's clearly not correct. But what we look at is what the legislature said. And what the legislature said is for plans approved before that date, they'll be treated without a sunset, and approved after would be. And it's clear they were intentional in the use of the word approved. Just if you read further along in that very end note, there's an instance where the legislature indicates amendments will cause a different treatment for certain other property within that same statute. So it's apparent the legislature was looking at what's the situation here. We're going to deal with matters that have been approved prior to that date, and they're capable, and they know to write in if there's any change, an amendment or otherwise, to affect it. They would know how to do that, and they have not. So it's clear that the sunset does not apply.
Mr. Miller, I want you to answer the same question I asked Mr. Lande, and that is it the city's position that it can actually expand the geographical area that is, it can get exemption of property taxes for beyond 20 years, that it can expand that area beyond the original 94 area.
What is occurring, Your Honor, I think we've acknowledged with the other areas, for instance, the eastern, the industrial, those are all affected by plans after the 1995 date and therefore included, had that sunset. The consolidation did go beyond to deal with, bring all them in for a particular area, and with respect to amendments to the Copper Creek plan, they would be permitted to be expanded.
So, just so I'm clear, so is it, because my sense is that what maybe concerned the Iowa legislature was sort of the unilateral ability of municipalities to kind of take property off the or to exempt property in part from property taxes, which has an impact on the entire county and on other municipalities and other areas. It's not just a Pleasant Hill issue, and they wanted to limit that. So, to be clear, is it Pleasant Hill's position that property that wasn't included in economic development area prior to the 95 or 94 legislation, property that wasn't included in an economic development area through a process of amendment and consolidation can become eligible for renewable or perpetual TIF financing?
Well, new plans would be subject to that sunset, and so if there's a new plan that's put in place after the fact, that would not be involved. But if through an amendment for the Copper Creek, that would be permitted.
Don't you see that that presents a real circumvention problem? Because you can just amend, you can get around the 20-year sunset just by amending your plan and adding in other land that wasn't designated, other real estate that wasn't designated in 94.
I suppose one way to look at it, that may be a circumvention, but I think if that's how it's being interpreted, and if the legislature has a difficulty with that, they are capable of going back and changing that provision. In fact, I think there's been legislation introduced in the past to deal with that issue.
But
Well, again, if we wanna-
under your interpretation, as long as the city has any plan in existence before 94, they could keep amending it and adding anything they want in it, and they'll avoid the 20-year limitation forever. I mean, that's
On new property.
a new property that's thrown on the plan.
I think that's very possible.
Was that the purpose of the statute, the 20-year limitation? There's no 20-year limitation because almost every major city in this state has a TIF district somewhere. So do you think the legislature intended, or her purpose was, only people who don't have TIFs before this date can't get into this game where we keep amending the own plan? But if you have a TIF, we're gonna let you amend forever. That doesn't seem in line with the purpose, as Justice Mansfield pointed out, and the intent of the legislature, because it's a non-functioning amendment.
Well, I think the legislature was dealing with plans specifically subsequent to 1995, and if read as they've stated it, you deal with those circumstances for 1995, and those prior are treated on a different footing. And some may interpret that as a loophole, but in fact, the legislature, if they're concerned that that is the case, they know how to close it.
Mr. Miller, does the authority to modify or amend a plan also authorize an amendment or modification of an area?
Well, the city has broad authority, Your Honor, to amend the plan and the area under the code. I'm not sure if I'm quite tracking your question.
Well, does the statute address the authority to amend the area within the plan? Or does it just address the authority to amend the plan?
The statute does permit, and then this court's interpretation is through faults. The statute does permit broad amendment of both plans and areas and ordinances for that matter, that the city can go back and deal with the different pieces of that as part of their activity.
What are the practical limits on the ability to amend a plan as opposed to at what point do you have to come up with a new plan that would be subject to the sunset?
Well, I think, Your Honor, I think if you're creating an entirely new section, that I think the limits maybe are political, that there might be a reason to create new areas or deal with a particular area with the intent for the sunset, or, for instance, when they created the eastern and the industrial areas, those were later in time, acknowledged that they had sunsets within those. I think probably if we went back in time, we would determine that the council had the attitude that those should expire at a certain period of time. But they're permitted to be consolidated and changed over time as well.
I guess I look at this somewhat like I would any other type of zoning, when we're talking about what Mr. Dickey was saying with the amendment to a wholesale amendment to a plan. Just like oftentimes when zoning comes into an area, then you have your property that's grandfathered in. In other words, even though it's a non-conforming use at this point, you can still use it, but then when you come later on and try to make wholesale changes in the plan, or in this case in zoning, in the building or the structure, then you're now subject to the new rules, which is, again, Mr. Dickey's argument here. What's wrong with that kind of logic?
Respectfully, Your Honor, I think it's contrary to the statute. If the statute intended for amendments to affect the earlier plans, it would say so. It says plans approved prior to that 1995 date are not subject to it.
But how would you read it if it says, and I think that's what the language does say, that it's not subject to it if it's consistent with what's stated in the plan, and now we have a new wholesale plan?
A wholesale plan derived from the city's authority to amend plans over time. So, I mean, I understand where you're coming from in the description, but that's not our precise scenario here, and it's not the language of the statute. It's not akin to the zoning as you're describing it.
Mr. Miller, if I understand your argument, you're just saying basically that the city can redefine the urban renewal area by modifying the plan. I mean, because that's what they do. They just add different urban renewal areas and redefine it.
Well, they can amend all aspects of it over time as necessary.
One of my problems is the code says, and it's 4035D, it says once and this is dealing with amendments and what amendments are allowed. It says once determined to be a blighted area, comma, a slum area, or an economic development area by the municipality, this was determined to be a economic development area, an urban renewal area should not be redetermined by the municipality throughout the duration of the urban renewal area. And aren't you, by amending these plans, redefining the urban renewal area?
Well, I think that needs to be read in conjunction with other portions of the statute, viewed in light of faults and other matters, and I think that that's permitted vis-a-vis that statute and the other case law. So I don't think we are redetermining. I mean, we're amending and changing. It's not.
You're redetermining what's an economic development area, what's not, by designating different land.
Well,
and that's what bothers me about the whole thing.
Okay. Yeah, in fact, I think we're not redetermining. We are adding to, modifying, changing that area. It's not.
But, yeah, but the area, it does seem to say, as I read 403.17.10, doesn't that support an argument that the 20-year sunset applies to an area? You can change the plan, do different things in the plan, but you only get the 20-year sunset to the area. I mean, you could see why this would concern the legislature, because if Pleasant Hill can indefinitely keep increases in value in Pleasant Hill property from being taxed, subject to property taxes, that affects like people in Altoona whose kids go to the Southeast Polk schools and don't get a vote on that. So, I mean, that's a logical division, wouldn't you agree?
I can understand the logical division. I can understand the concern. We're not legislature. We're here dealing with the legislature and what they have approved already. If that is their concern, they can go back and deal with those type of issues. TIF is readily an issue for the legislature, but we're dealing with the statute currently in front of us, Your Honor. If I can briefly touch on the issue with respect to conformity with the comprehensive plan, the city believes it's clear that McMurray applies in this case. Knutson, while generally in this vicinity of the area, In fact, dealt with the situation where the plan in that case specifically foreclosed or prohibited a particular use. That's not the case here. The use proposed by the city were all consistent with the comprehensive plan. There's no restriction, for instance, on the extension of the roads that are complained of here. They were generally, as the district court found, anticipated to be expanded or changed over time. So we believe McMurray is directly on point. McMurray was followed, in fact, by Fultz, where this court re-emphasized that the courts should look at specifically the city's actions, not the prospect of some future development. There's all sorts of information in the record about a purported warehouse. Of course, there's information in the record as well with respect to the fact that there was no clear plan, and for there to be some determination at this point in time with respect to whether or not the possible plan would conform with the comprehensive plan, effectively asked for an advisory opinion. We think that's inappropriate, and that's not what you counseled in McMurray. So for all the reasons stated in our briefs and here today, we ask the court affirm the Court of Appeals and the District Court. Thank you.
Thank you as well, Mr. Miller. Mr. Dickey.
May it please the court. Justice Mansfield, I want to follow up on your question because I feel like we're really close, but maybe not quite there. The three concepts of an urban renewal area, urban renewal plan, and the TIF ordinance in TIF district are three distinct concepts, and that's where the district court ran into problems, was confusing the three. They each serve different functions and have different limiting principles. So the first thing a municipality has to do is set up an urban renewal area. After that, the municipality can establish a TIF ordinance, which creates another geographical boundary that oftentimes is the exact same boundary. It can be smaller, but it cannot exceed that. The purpose of the urban renewal area is to designate that area under which the urban renewal plan can carry out projects. The TIF district simply sets out the geographic boundaries for diverting the revenue, okay? So a municipality, to get to your point, could amend the urban renewal area, but unless they also amend the TIF geographical boundary, they're not drawing new money in, right? Because it's the TIF boundary that determines where the money is coming from. Both of those, however, are limited to the third concept, which is the plan, and the plan limits how that money gets spent. So we take the position that the municipality can change the TIF district, they can change their geographical boundaries, because we have that limiting principle that says that money, which is diverted, has to be limited to those projects that are identified in the urban renewal plan. And that's, to your point, Justice Appel, the price of admission in modifying or approving an amendment to that plan is that you bring your urban renewal area, which is a purely economic development area, within the 20-year sunset. And I think, Justice Wiggins, you get to the heart of the parade of horribles that would follow if this court allows the Pleasant Hills TIF regime to remain. And that is, if you think about the actual property that's involved in this case, back in 1994, that's the geographic area that was wholly undeveloped, and today it's a golf course, very expensive homes, a movie theater. It is essentially fully developed. And so from the legislature's perspective, there's no need to continue, there's no need to limit that because its natural life cycle has played itself out. The problem is, what the city wants to do is to take the incremental revenues only from that TIF district, right? So not throughout the other urban renewal areas, but only the TIF district, because that ordinance has not been amended, and use that to fund projects throughout the city.
What was did the record show the length of the original bonds for the original TIF district?
Your Honor, that's not in the record. I mean, I think conceivably they are longer than 20 years, which might also be a reason why the legislature...
Did the legislature, that's my point, did the legislature do this 20 years because they didn't want municipalities to extend themselves with more than 20-year bonds? I mean, was that one of the purposes of it?
I think that would be a rational conclusion to draw, is that you have municipalities, although this is not in the record, we'd be speculating, but municipalities who are drawing debt much longer than 20 years, and they wanted to limit the amount of debt they could draw. but then, you know, they couldn't impair the contracts that were already in place.
So it makes sense that with the financial situation back in 2004 or 5 when they did this, or whenever they did this, it was pretty bad over those years, that they'd want to limit the debt, time of the debt that a municipality can have. And of course, what Justice Mansfield talked about, make sure that other people who can't vote in the area aren't impaired by the same decisions.
I think the general understanding of the purpose of TIF is to allow a geographic location to build itself up. And then once that's happened, the city needs to move on to a different area. And so what we were seeing is these perpetuity economic development plans that had no limit, and the legislature said, unlike slum and blight, that's not the best use of resources.
In a TIF area, once the roads are developed and the infrastructure's in there, what more reason does the city need the money for the area? Shouldn't it either be sink or swim, be it self-supporting or not self-supporting?
I would agree. I think that's the policy behind the 20-year sunset.
But you acknowledge that the city can use the TIF financing for things other than financing that area as long as it's within the 20 years?
Well, so that, not necessarily, Mr. Chief Justice. That's subject to the limiting principle of the urban renewal plan. And so they've got a 1994 plan, and they can use the TIF revenues to fulfill the purposes of that plan, but when they change and alter the aspects of that plan, then that's an entirely different proposition. So for those reasons, we would ask that the district court's ruling be reversed. Thank you.
Thank you, Mr. Dickey. The case is then now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.